Hello, I'm Nadia MacLeod from RP Emery Legal Kits, and we help you cut your legal costs with our online template kits. You may have heard the term at arm's length thrown about in relation to commercial transactions, but what exactly does it mean? When parties are negotiating commercial transaction, there is an expectation that both parties are at arm's length. Put simply, this means that both parties are independent of one another and operate with their own self-interest. When engaging in negotiations, there may be certain information withheld by one party that the other party is not privy to. Let's look at an example. In a 2018 case heard in the New South Wales Court of Appeal, the court held it is unreasonable to expect a landlord to reveal prospective tenant information to existing tenants. It noted that there might be situations where one party does not inform the other party of something which could impact their negotiating position. Put simply, withholding information is not considered unconscionable conduct. There is also an obligation on a self-managed super fund trustee to negotiate at arm's length. For instance, if you are a self-managed super fund trustee, you must record any purchases accurately to reflect the true rate of return. So what does all this mean in practice? While there is no obligation to bring information to the attention of the party you are negotiating with, this doesn't mean that you should be dishonest. Always exercise caution and ensure you have key terms documented in all your agreements. In summary, the concept of arm's length is an important principle to be aware of when engaging in commercial transactions. If you would like to read more, you can read our article, which is linked below.